Good evening, Section Z. Tonight we're going to take a look at a case called Othon versus Rosier. So let me share the screen with you on that. Here we go. It's over on page 508 from Texas. We're dealing with easements here. This is a case where somebody filed a suit to try and establish an easement, and it turned out to be a kind of a bad idea. Let's take a look at the layout of all of the property in question here, which is, I think, over on page 509. Othon owns a couple of lots. He owns a 53-acre lot, which is right here, and then the 60-acre lot next door. And those lots don't border on any public roadways. So when he needs to get out of his place and get to a public road, he has been traveling over land owned by a neighbor, the Rosier family. And so the Rosiers actually have a couple of lots as well. They've got a little 16.31 acre lot here, and then next to it, a 100-acre lot, and the 100-acre lot borders on a public road. And so plaintiff has been using this roadway that travels over both of those lots owned by the Rosiers when he needs to get out. The litigation takes place because the Rosiers constructed a levee along the side of the roadway. And the result was that the roadway became muddy and impassable for weeks at a time, except if you are on horseback. And so Othon is claiming that he has an easement to drive over their property, and that the Rosiers are obstructing his easement, and so he wants them to fix the road so that it won't flood. The author said that one time they were teaching this case and they asked a student to recite what had happened. The student said, well, Othon drove his Chevy to the levee and the levee wasn't dry. So his first theory is that he has an implied easement by necessity. The court has a set of elements that you have to establish for an easement by necessity over on page 511. They say there has to be unity of ownership of the alleged dominant and servient estates, that the roadway is a necessity, not a mere convenience, and that the necessity existed at the time of the severance of the two estates. There's another way of articulating those elements in note 2 after the case, and then here in the box by note 2, they kind of give you initial unity of ownership of the now dominant and servient estates, followed by severance, and then strict necessity at the time of the severance. So what does, one question is this the same theory that we were looking at in the Van Sant versus Rosier case, or Van Sant versus Royster case that we looked at in the last lecture? They sound kind of similar, right? Because both of them have to do with property being severed into multiple pieces. Both of them have to do with some showing of necessity. Both of them have to do with whether you can imply the existence of an easement even when it is not mentioned in the deeds documenting the transactions. And so is this just the same theory in another case illustrating that theory? The answer is no. This is actually a distinct theory in the Van Sant case that we looked at in the last lecture. There, the basis for implying an easement was slightly different. There you had to show that there was a quasi-easement, that there was an existing use of one part of a person's property for another part, and then at the time of the severance that existing use was apparent and continuous and necessary. Here, it doesn't matter whether the use was existing at the time of the severance. The question is whether the use was necessary at the time of the severance. And they seem to require a higher showing of necessity here, strict necessity, as opposed to a reasonable necessity that we saw in the pre-existing use case. So if we think about those elements over on page 511, let's think about whether those are satisfied here in Othon's claim for an easement by necessity. First, that there is an unity of ownership of the alleged dominant and servient estates. Well, on that point, yes, there was a time when both the 100-acre lot owned by the Rosiers now and the 53 and 60-acre lots owned by Othon were all owned by the same person. This was kind of back before the turn of the 20th century, late 1800s. All of them owned by somebody named Hill. There are a lot of different transactions that Hill engaged in that the court discusses, but the one that turns out to matter is an August 26th, 1896 transfer when the 100-acre tract that lets out onto Beltline Road was sold. And so the issue is whether in making that transfer back in August of 1896, Hill reserved an implied easement over that 100 acres that was necessary for access to the Hill's remaining property, including the 60 acres and the 53 acres that are now owned by Othon. And so what does the court conclude? Has Othon established an easement by necessity at the time of the 1896 transfer? And the court decides no, that the evidence that was submitted was insufficient to show that public access over the 100-acre lot was necessary at the time of the August 1896 transfer. We just don't know enough. It could be that Hill had other ways to get out of his property to a public road at the time that that transfer took place. So that disposes of the easement by necessity claim. Othon has another argument. He says that he has an easement by prescription. We'll get into this more in our next lecture, but basically this is kind of like adverse possession, except that what you're trying to establish is not title to land, but instead an easement or a servitude, the right to use somebody's land by virtue of showing some of the things you'd have to show in an adverse possession claim. And so does that claim succeed? The court says, no, that one doesn't work either. And that's because the plaintiffs were using the Rosier's roadway by permission. And so it was not adverse to the interest of the Rosiers. And so the easement by prescription claim fails. So Othon is left landlocked. His attempt to establish a right to travel over the Rosier's property fails. What are his options at that point? Well, I guess he could ask Rosier for the right to purchase some land or a strip of land or an easement over Rosier's land so that he can get out to a public roadway. Kind of the downside of that option is that he's just sued Rosier, and so Rosier may not be feeling particularly cooperative, may not want to deal with Othon. He might have another neighbor or another set of neighbors that he could deal with to try to purchase an easement to get to a public highway. Alternatively, he could have a title searcher go and do a more complete job of reconstructing all of the conveyances from Hill. And if the title searcher went and did that work, then maybe they would be able to prove the exact point in time when the 50 acres and the 63 acres that are owned by Othon actually became landlocked. And if you could prove that, then maybe you could show a particular transaction in which there would be an implied easement by necessity. I guess another possibility is Othon can look into helicopters or something. Note 1 after the case on page 514. The court or the authors talk about what is the rationale for permitting the implication of an easement by necessity in a case where the parties did not kind of actually did not indicate that they were creating an easement, in the documentation, the deed that resulted in the transfer. And so there are a couple of different possibilities. One is a public policy rationale that we think it is a good thing for there to be access to land. It makes the land more valuable. And so we imply an easement by necessity to effectuate that public policy of wanting there to be access. The second is the argument that, well, this is probably the intent of the parties, that if there was a need for an easement for one of the parties to have access to a lot, then you should assume that the parties intended for there to be an easement in the course of the transaction. Now, notice the case here from the Georgia Supreme Court back in 1997. There, the court decided that they would not imply the reservation of an easement by the grantor. Maybe different question if it's the grantee, but if it's the grantor claiming that they implicitly retained an easement, the Georgia Supreme Court has a case saying that that's not a theory recognized. So note 3 gets into the question of, what do you mean by necessity? When you say that there has to be necessity for the implication of an easement by necessity, what kind of necessity are we talking about? And necessity is kind of one of those classic issues of degree. You can have things that are reasonably necessary, strictly necessary, and so just how necessary does it need to be? And the courts on 514 and 515 tell us that most courts, like the court in Othon, require strict necessity. They say some courts have granted an easement by necessity where access to the land exists, but it is claimed to be inadequate, difficult, or costly. And they tell us that in a few jurisdictions, a surface way of necessity will not be implied if the tract has access by navigable water. So it seems to be a stricter requirement of necessity for this kind of an easement than for the easement from pre-existing use that we saw in the Van Sant case. So take a look at problem 4, or note 4, on page 514. A owns 5 adjoining tracts of forest land numbered 1 through 5. They actually have this laid out for you in a box at the top of the page, but so you can visualize it. But all 5 lots previously were owned by O as a single tract. A has purchased each lot from O in a separate transaction. And then lots 1 and 2 are bounded by a public road on the north, lots 3 and 4 are bounded by a public road on the south, but lot 5 doesn't have any access to a public road except through one of the other 4 lots. We're then told that A dies and has 5 children who are A's heirs, and the court distributes the 5 lots, 1 to each of those 5 children, so that B gets lot 1, C gets lot 2, D gets lot 3, and so forth, with F getting lot 5, the lot that does not have access. And the decree distributing the lots doesn't say anything about an easement in favor of F. So sometime later, when F wants to actually use the lot, F sues the siblings, the owners of lots 1 through 4, claiming an easement by necessity. So should the court recognize an easement by necessity in favor of lot 5 owned by F? The authors think that there should be, but then that kind of raises the question of, well, where do you put the easement? If you put it over lot 1, that doesn't seem particularly fair to the owner of lot 1, or same for lot 2, or so forth. And so how do you deal with the problem of granting F access, given that it's going to create a burden on one of the other lot owners? And the author suggests that, well, what you could do is just locate the easement where it will impose the least cost, and then you could ask the other lot owners to contribute to that cost. They have a couple of cases cited here. One is Horner versus Hirsch from Kansas. In that case, there was an auction to sell 3 lots. The lot that needed access was sold to one person, and the other 2 lots were purchased by another person. And the court decided to imply a way of necessity in favor of the landlocked lot, since the owner of the other lots had already established an access road. That's what they selected. In the McQuinn case, there were 2 lots that were sold simultaneously by the same owner to different people. The court in that case decided not to grant an easement by necessity to the landlocked lot because there was access by water, and also because they didn't think that they should grant an easement by necessity over the lot of a stranger. The authors think that's kind of odd reasoning because they were commonly owned at the time of the sale. And so you could just apply the theory of easement by necessity and say that there was a lot over the original common owner's lots that carried over to that lot when it was sold to the other purchaser. Note 5 on page 515 talks about one way that an easement by necessity can end. It's created by necessity, and so if that necessity ends, then the easement also ends. And so if the dominant owner secures another way out from the landlocked parcel, the easement by necessity is finished at that point. And so the authors ask, in Van Sant versus Royster on page 501, suppose that the city constructs a public sewer in 10th Street and that the owner of lot 4 can connect with it. Does the owner of lot 4 lose the implied sewer easement over lots 19 and 20? And the answer is no. And this is one of the reasons why it matters that we distinguish between the implied easement from pre-existing use and the implied easement by necessity. So an easement by necessity will end when the necessity ends. But if it was an easement by pre-existing use, the end of the necessity does not automatically end the easement in the same way. Now, note 6 on pages 515 and 516, the authors note that in some states, a party who is landlocked can condemn an easement over neighboring land. And so effectively, they get to exercise part of the state's power of eminent domain and force a neighbor to sell them an easement, but they have to pay for the easement that they are acquiring in that way. The authors ask the question, why should the servient owner of a common law easement by necessity receive no compensation, whereas the servient owner of a privately condemned easement by necessity receives compensation from the benefited owner? The author suggests that maybe one reason for that distinction is that one of the rationales for the common law easement by necessity is that we assume that it was intended by the parties. If there's a transaction where a lot is being sold and it would be landlocked without an easement over the other property, then we assume the parties intended for that easement to come into existence. If we make that assumption that it was intended by the parties, then perhaps we should also assume that that was factored in setting the purchase price. So effectively, whatever price was set in that transaction, we can assume took into account the cost or the value of the easement or the decrease in value of the servient tenement as a result of the easement, and that they transacted accordingly. So maybe that's enough of a reason to distinguish the two situations. So that's a good stopping point for easement by necessity. Next, we will talk about easements by prescription.